the 6-month waiting period, also known as the cooling off period, is not required anymore for getting a divorce. The Supreme Court ordered today, it further held that the mandatory waiting period of 6 months for divorce in cases of mutual consent, that is in a divorce between consenting parties, can be done away with subject to some conditions. A Constitution bench of the Supreme Court today ruled that the court can dissolve a marriage in the case of an irretrievable breakdown by dispensing with the need of the waiting period, which is currently required under marital laws. A divorce is of course a process of the dissolution of marriage in a legal procedure. In order to get a divorce petition is filed in a court of law. Once a decree or a judgment has been passed by the court in favor of the divorce petition, the marriage of the spouses terminates. But under section 13B.2 of the Hindu Marriage Act, both parties seeking divorce have to wait between 6 to 18 months from the date on which they presented their petition to obtain the divorce decree. Now, this 6-month period is given so that parties have ample time to withdraw their plea if they'd like to. But joining us for more on today's Supreme Court order, Malvika Rajkotia, an advocate of the Supreme Court, an author of Intimacy Undone, a book which explores the patriarchal world of divorce courts. Also, Mrinalini Deshmukh, senior marital lawyer from the Bombay High Court, joining us. And we also have Rachna Shukla on the news at 8 tonight. I beg your pardon. Malvika Rajkotia, to you first. Is this, and if so, why is this a landmark order? Is this a progressive order? What does it mean on the ground?
Yes, it is a landmark order, and not just for the reasons that you have mentioned, because it's not just about the cooling off period being waived, because that was always there as discretionary. What is important here is that under Article 142 of the Constitution, the Supreme Court has the power to do what was called to complete justice, certain residuary power to do complete justice in a matter. And the question was whether it could exercise that power to grant a divorce even when there was no mutual consent, once two contesting parties, after very often decades, have reached the Supreme Court. And what is landmark is the message that the situation is not just that prevailed at the time of filing of the petition, but all the subsequent years, because it's a dynamic situation, and long separation by virtue of the filing or because of the refusal of a divorce, or even if there is refusal of divorce, there's hardly ever a resumption of cohabitation anyway. Yeah. Could then be an instance for the court to do complete justice and actually grant the divorce, notwithstanding contest.
No, okay. But so can I ask you this, Ms. Rajkotia?
It is a landmark because we subscribe, yeah.
Why would a divorce case have to go all the way to the Supreme Court? Can it not be, should it not be handled at the family court?
It is. The starting point is always the family court, but where there are substantial rights involved, which there are here, in every family law matter is substantial individual rights, child rights, property rights. So obviously in the realm of contest, by the hierarchy, it would culminate in the Supreme Court.
All right. And
very often there would be that many years that would have gone by, and the court empathizes with that condition and says, we will retain the power to do complete justice then.
And that's how they brought up irreparably, when you say a marriage is irreparably.
Of residuary power which can be... Yes.
Sorry, we're having a delay. Mrinalini Deshmukh, then could you explain to us, is that why, and the court mentioned today in its order, the case of irretrievable breakdowns of marriages? Could you explain that, the use of that term in this context?
Okay. So I think we need to understand how the marriage laws in India work. So there is what is known as a mutual consent divorce, and the other one which is known as a contested divorce, where one of the parties is seeking divorce, the other one is opposing for various reasons.
Yeah.
Some of the reasons could be they want to save the marriage. The other reason could be because he or she is not agreeable to the terms of the settlement, and that is why mutual consent is not happening. Or the third reason would be other various reasons where their children are very young, they want a divorce, but they want to keep the family ties together, and so on and so forth. Unfortunately, in India, we do not have what is known as a no-fault divorce. If I want to divorce my spouse, then I have to either take his consent, so it's a mutual consent, or if he doesn't do, then I have to go on what is known as the fault grounds of divorce, which is either cruelty, desertion, etc. So I have to prove those grounds that there was cruelty perpetrated, mental or physical, there was desertion, there was adultery, so on and so forth. There is not even today in our marital legislation, which is the Hindu Marriage Act, Special Marriage Act, etc., a ground which can be used, which is an irretrievable breakdown of marriage, which was also a suggestion made by the Law Commission. At some point of time, if I'm not mistaken, Justice Ajit Shah was the person who had made this suggestion that this should be included as an irretrievable breakdown of marriage, should be included as a ground. But I think we, India as a society, and we, India, are really not still matured enough to take that kind of a call. So we do not have a change in the legislation, which is what I would want to canvass. It is the need of the hour, seeing the pendency of the cases, seeing for 13, 14, 15 years, the kids who were 0 or 1 have become into 18. The parties who are in their 30s have gone into 50s. And the courts, and with utmost respect to them, come and say, we are sorry. You have not made out a case of cruelty. You have not made out a case of desertion. So divorce is granted, stay languishing in it. I think this is where this order, which is a landmark judgment, as my learned friend and my personal friend Malvika has stated, the irretrievable breakdown of marriage. The courts are going to say one petitioner wants a divorce, the other one is saying no. But we as a judge under 142 and under the article that gives me substantive inherent powers to do substantial justice, deem it fit in the given set of circumstances that the marriage should be dissolved. What happens, I'll just take 30 seconds more. What happens overseas is the divorce is given for the asking. What needs to be contested in certain cases are the alimony, ancillary reliefs and custody.
Sure.
But in India, we have to struggle even to get a divorce. I mean, really?
All right. So what will change on the ground? Will it come? And how soon? We have Rachna Shukla here, who is a divorce petitioner herself. Rachna, sorry, one second.
Can I just step in? Can I just say one thing for that? Can I just say one thing?
Go ahead.
Yeah, just that the message needs to go down. So the important thing is, it's an important message across the country, right down to the family court, that the approach to divorce is more liberal. And that's
the approach to divorce is more liberal. Rachna Shukla, you are a petitioner in court yourself. Your reaction, what did you feel like when you heard today's order?
I'm not a petitioner. Petitioner is the husband and I am the respondent.
All right.
Yeah. So today's order has actually two parts to it. One is, waiving off the cooling off period of the mutual consent, which I think is really good. And the trend has already started on this. So it doesn't come as something new to me, but it seems that it has been reinforced.
Yeah.
Now, the second part is irretrievable breakdown of marriage. So what happens is, under most circumstances, so is in mine, adultery, cruelty, irretrievable. The three things are there, the standard things with the husband. He will just go to the courts and say that these are the three grounds and therefore please kindly grant me the divorce from this lady. And now what happens to the settlement? What happens to the permanent alimony? What happens to the factor that you have spent so many years serving the person and their household? What happens to, considering the age at which I am, and if there are children involved, what happened to them? Correct. So those factors are completely ignored by the petitioner In my case, it's the petitioner husband. And what happens is, just because these three grounds seems absolutely correct to them, then it becomes irretrievable breakdown of marriages. So now, off recently, I think this judgment is fantastic, and the grounds which have been laid down describing what irretrievable breakdown of marriages is really going to go down to the family courts, and they're going to consider it really wisely now, because a lot of petitioners, especially if they happen to be husbands, started picking up this trend of approaching the courts under Article 142(2) or 226 to the high courts. They have suddenly picked it up as a trend because probably they do not have enough material with them to proceed during the evidence.
Okay, so you now at least we can hope that the message will percolate down to the family court levels.
There is no other way. It will.
Thank you. A big day, a huge day today, and thank you for helping our viewers understand what actually happened today and what a difference it could make to many lives, to families, to children going forward. Thank you all for joining us on the news at 8.